Hope so.
Uh, so yes, we have quite a few people joined in.
Mhm.
Uh, so we take a step forward from yesterday. We were looking at constitutional remedies yesterday, but we today look at focused on one particular area of work for lawyers, as well as something which is very, very important for the public at large. Employment has been a major sort of mainstay of any civilization, and for it to be democratic and effective, you need a full independent governing mechanism. Also, you don't want the people working to be completely not under working control. So the thin line of balance is sought to be sort of achieved through the various rules and regulations. We're today talking of more specifically the public sector, or the government, semi-government employment regulatory framework, the CCA rules. Sandeep, as all of you know, is from a chamber which had tremendous background of this particular law, and he himself has done a more than a fair amount of work in the area. So, Sandeep, over to you to take us all through people who have worked in this area and who have not worked in this area equally. Please take us through a walk through the CCA rules and what should be the approach of a young lawyer there. Over to you, Sandeep.
Good morning, everybody. So today we are just taking a brief idea about about the provisions of the CCA rule and how it works, and as to the scope of interference in those rules in the orders passed in pursuant to those rules by the Honorable High Court. I'll try to frame my the session in four different sections as to the genesis of the rule, the classification, the procedure, and the last part will be the appeal part. So, as we all know, the principles of natural justice are the basic idea and the basic thread with regard to the administration of serving of the people are concerned, and that principle came to be adopted from the Constitution. Uh, Except for other provisions, Constitution has been the fountainhead of that principle. So, first of all, the source of the power has to be seen. The source of the power, as far as the rules are concerned, that is available under Article 309 of the Constitution of India, which says that the act of the legislature, concerned legislature, be it the state government in case of state legislature and the union government in case of service under the union, shall have the power to frame the act for governing the recruitment and the conditions of service of the employees thereunder, respectively. However, proviso is very tricky. The proviso thereunder gives the power to the governor or the president, respectively, to frame rules until and unless an act in this regard is framed by the union legislature or the state legislature, respectively. In Rajasthan, typically you will find that in most of the service rules, the powers have been exercised under the proviso to Article 309 by His Excellency the Governor. As far as the classification, the CCA rules, that is what we call in short, the full name is Rajasthan Civil Service Classification, Control and Appeal Rules 1958. The same has been framed exercising same power, the proviso to Article 309 by His Excellency the Governor, and it covers the field with regard to the employees, government servants. I'm sorry, government servant, that is the employees working under the civil post of the or service under the state government. So prior to understanding this fact, we have to understand this thing also, that a government servant is different than a public servant. Government servant are those persons who are working under the specific rules framed under proviso to 309 and serving the government themselves. While public servant might be other persons who are, though working for a local body or an authority or an instrumentality of government, but they are not government servant. For example, an employee of a university, though it is a government body, local authority, municipal employee of municipality, though it is a local authority, but they are a public servant but not government servant. So the first part is with regard to the applicability of CCA rules. rule definition is there under rule 2 and 3. I won't take you to the definition or all the provisions step by step. I will just I won't read the provisions. I'll just broadly go through them for the convenience and to ensure that we complete the session within the time frame. So the rules define a government servant and specifically state that even if the person is working on deputation also, which will be specific provision is there. That is the reason why I'm referring to the deputation. 19A of the rules is with regard to the deputation. So the persons who are on deputation also, the CCA rules have been made applicable to them also, and the persons who are holding a civil post or working under the providing service under the government of Rajasthan are under the control of CCA rule. So the as the rule itself suggests, classification, control, and appeal. So the classification of services, control means as to how the disciplinary proceedings are undertaken and what is the control of the state government. And appeal is the remedy part, for which we'll deal with in the last session. So classification. So for understanding, there was a query which I had till long time as to what are the services under the state government, how to classify them. So the answer lies here, because all young lawyers should definitely go through this rule to understand the how the state functions, how the state functionaries work, and how the services are classified. There are queries as to who are the head of the department, who is the head of the office. So all those queries have been detailedly answered in this rule. So first part, classification of service. As far as Rajasthan is concerned, we are having four types of service under the state government. First is the state services. Second is the subordinate services. Third is the ministerial services. And fourth is class 4 services. State services have been specified in Schedule 1 to the rule. Subordinate services, as to who, what all will be subordinate services, have been specified in Schedule 2 annexed to the rules. Ministerial services and class 4 services are altogether different. Now, as far as I'll just give few examples to help you understand this thing. As far as ministerial, class 4 services are concerned, driver, chowkidar, jamadar, they all form peons, they all form the class 4 services. Thereafter, ministerial services is all like LDC, UDC, office assistant, all persons discharging ministerial duties and who are governed by the ministerial service rules, which are common. Class 4 and ministerial service rules are common rules for all services. So these are the ministerial services. Now, subordinate services, if you have gone for all those persons who have um, undertaken the litigation under the service law or dealt with service cases, you might have seen that there are services like police subordinate services and police services, Rajasthan police services. So the police services govern the case of state services, and police subordinate services govern the case of employees of police department or home department under the subordinate services. So persons like inspector, etc., fall under the subordinate services. For higher posts, DIG, IG, SP onwards, it is the state services, that is state police services. Now, for understanding further the services, although there is no classification, but for easier understanding of the services with regard to applicability of the rules also, we can broadly classify services into two forms. One is fundamental rules and another is supplement rules. Now, fundamental rules will be such which will be common for all services, be it police services, police subordinate services, ministerial services, or any other services, education services, irrigation services, all forest services. So there will be common fundamental rules that can be classified as, for your better understanding, Rajasthan service rules, the CCA rules, civil this revised pay scale rules. They all will be common irrespective of the post for all services. Second part is the supplement rules. Supplement rules can be understood like wherein the provision is. I'm sorry, I'll just deliberate a little more with regard to the fundamental rules. Fundamental rules provide the leave which you can take, the disciplinary proceedings which you can, which shall be undertaken, lean, study leave, transfers. Thereafter, there is increments, pay scale. These all are dealt with under the fundamental rules, which are common to all. All aspects have been dealt thereafter. As far as supplement rules are concerned, as to what shall be the channel of promotion, what shall be the criteria of promotion, what shall be the criteria for recruitment, what is the qualification required, age required, which is typical for each service. Like, for example, for uh, police subordinate service, it will be different. For education subordinate service, it will be different, and which will be unique to each post also. So, that is fundamental services, fundamental rules. Now coming back to CCA, I'm sorry for this intermingling. Now coming back to CCA, CCA, as we all can understand, it is a part of fundamental rules, which is applicable and common to all services. So classification part we have dealt with, four classification of services. Now coming to the second part, as to rule 12 is important as to who shall be the appointing authority. The appointing authority has been specified that as far as state services is concerned, and this can be correlated with rule 15 as to who shall be the uh, disciplinary authority, because nobody less than the appointing authority can proceed with the disciplinary inquiry against the delinquent concerned. So, appointing authority as far as state service is concerned shall be the state government, that is the governor or any person authorized by him. As far as the subordinate services and the ministerial services is concerned, shall be the head of the department or the person who is authorized by the head of the department. And as far as class 4 services is concerned, shall be the head of the office or a person as specified by the head of the department. Who shall be the head of the department has again been provided in Schedule A of this very rules itself. You can go through them to understand as to for each department who is the head of the department. Now coming to this part of suspension, which is very important provision under the rule, and to ensure that the person concerned doesn't interfere within the pending inquiry or the investigation, the power of suspension has been provided, which can be exercised under Rule 13. You'll find many litigation as far as service law is concerned on this aspect, that is whether suspension was justified or not, and whether the suspension was by the by the authority competent or not. So Rule 13, broadly speaking, specifies that appointing authority or any authority to which it is subordinate can place a government servant under suspension in case of contemplation of a disciplinary inquiry. I'll emphasize again contemplation of a disciplinary inquiry. So it is not necessary that a charge sheet should be issued, because disciplinary inquiry commences after issuance of charge sheet. So mere contemplation is sufficient. Contemplation of disciplinary inquiry, or the person is under arrest or I'm sorry, there is an investigation or trial going on pertaining to a criminal case against him. So these are the contingency under which the person can be placed under suspension if the authority is of the view that continuation in service of a person shall be detriment to the pending investigation or inquiry or the trial, whichever is going on in the criminal case. Now, there is a provision that, as far as suspension is concerned, sub rule 5 is there, which says that it can, I'm sorry, sub rule 2 is there, which says that if a person is behind bars for 48 hours, then there is a provision of a deemed suspension. Although an order has to be passed, but the suspension should be deemed to come into effect on the date of his being under the bars. So, deemed suspension provision is there. And thereafter, 13.5 is important. 13.5 says that there is a power with the state government or the authority which had passed the suspension order to review its order. So, suppose a person is rightly placed under suspension. Now, some time has elapsed and circumstances have changed. Or rather than paying him subsistence allowance for a longer period, the government decides that there is no harm or to the inquiry or investigation which is going on. He can be reinstated then, reinstated under 13.5 also. So that is about suspension as far as the lawyer's perspective is concerned. The law is settled that as far as the fact finding part is concerned, suspension cannot be interfered by the court. The court should be very slow to interfere in, as far as suspension orders are concerned. And the grounds and the yardsticks for interference are that the order is without jurisdiction, not passed, that is not passed by the competent authority, there is a total non-application of mind, or that there is an act of malafide. And further now, it has been developed that in case of continued suspension for a longer period, since 1992, you can find many judgments on this aspect, that continued suspension for a longer period, then it is not justified and that can be set aside by the court concerned. Suspension, largely speaking, that is, it covers the case of suspension. Yes, there is one contingency wherein the order is passed by authority authorized by the state government, but it is not high, but it is lower in rank to the appointing authority. In that case, this immediately after passing of the suspension order, the order is to be sent to the appointing authority, who shall ratify the suspension order. Immediately means immediately. If there is any delay and the suspension continues, then the suspension is without jurisdiction and that has to go. So now moving forward, post suspension, the question comes with regard to penalties. Now, penalties have been specified under Rule 14, wherein seven types of penalty have been specified. First is censure, second is stoppage of increment or promotion, third is recovery to the lost cost to the government, pecuniary recovery to the lost cost to the government by the act of the delinquent. Then thereafter, there is stoppage of reduction in rank or pay scale, then compulsory retirement on proportionate pension, then removal and dismissal. So first three penalties have been considered as minor penalties. The residual four penalties have been considered as major penalty. Censor is a warning that you may be careful in the future. Then reduction, increment, Rule 29 of RSR says that the increment, yearly increment which an employee is entitled as per the pay scale rules, has to be granted as a course, and it can be stopped only if there is a specific order in this regard under CCA. So stoppage of increment or promotion is that if a person is like entitled to an increment of rupees 1,000 per year on 1st of June, say the date of increment is 1st of June every year, then a penalty of stoppage can be imposed that yes, your increment won't be granted. Now, there are two contingencies in this also. Stoppage can be with cumulative effect and without cumulative effect. With cumulative effect will have an impact lifelong upon the increment concern, and without cumulative effect will have an impact for that particular period for which it has passed. Say like for 1 year, then it will have an impact for 1 year only. That is, suppose, to understand it more easily, suppose my salary is 12,000. I am entitled to an increment of 1,000 rupees. So my salary is 12,000 in 2020, and in 2021 it will be 13,000. 1,000 is the increment which I am entitled to. A stoppage of increment without cumulative effect for a period of 1 year is imposed. So for the year 2021, I won't be getting 1,000 rupees. But immediately on June 2022, I'll be getting 1,000 plus 1,000. That is 14,000. My salary will be 14,000. So the period of non-grant of increment shall be only 1 year, meaning thereby that after elapse of 1 year, I'll be granted that notional benefit of 1,000 and plus 1,000. So 14,000 will be my salary. Whereas in case if it is with cumulative effect, then I won't get this 13,000 ever, 1,000 ever. So in the year 2020, my salary is 12,000. In the year 2021, again my salary is 12,000. But in the year 2022, I'll be getting 13,000 and not 14,000.
We have lost the voice. We have lost the voice.
Yes, sorry.
Yes,
Yes.
back on.
Okay. So reduction in rank and reduction in pay scale is very simple. Like from UDC, I'm reduced to a my rank is reduced to a LDC. My pay scale was 12,000 and I am reduced to 11,000. So that is reduction in rank. Now compulsory retirement is as such under RSR. Hello, hello. Yes, am I audible?
Yes, sir,
Okay.
you're audible. You're
Yes,
audible.
you are audible.
Yes,
Uh,
yes. Okay, thank you. So, reduction in, I'm sorry, compulsory retirement as such provided under the RSR and pension rules. But as a punishment, also compulsory retirement can be imposed. Like the original idea of compulsory retirement was to chop off the dead wood. But even as a punishment, if it is found that yes, continuing of the person in the service is not appropriate, even as a punishment post disciplinary inquiry, compulsory retirement can be imposed and he will be granted the proportionate pension thereafter. Now, there is a very fine distinction between removal and dismissal. Removal is not a bar to future employment. Suppose I am removed and thereafter a fresh recruitment is issued, advertisement is issued, then I can participate and my removal won't be a bar to future recruitment. However, if I am dismissed, it will be a bar for future employment unless and until it is specifically so specified by the authority which has passed the punishment. So this is with regard to the penalty, which are which can be imposed under the CCA rules. Rule 15 again deals with disciplinary authority and says the same thing, that as far as services is concerned, the state government, that is the governor or a person authorized by him, subordinate and ministerial services concerned, the head of the department, a person authorized by him, and as far as class 4 services is concerned, the head of the office shall be the disciplinary authority. However, it is specified that as far as removal or reduction is concerned, the power cannot be subdelegated. It has to be exercised by the head of the department or the governor or the person acting on behalf of the governor himself, and it cannot be subdelegated. Now, prior to proceeding with the procedure, I would again take you back to Article 310 and 311 because that will have a bearing upon the procedure also. As we understand this thing very clearly, that the principles of natural justice are the thread line which govern the rule and the basic idea. But contrary to it, there is a provision of Article 310 that talks about the doctrine of pleasure. Says that any person who is working under the union, the services of the union, all India services, is working at the pleasure of the president, and any person working under the service or holding a civil post on the state government is working at the pleasure of the governor, meaning thereby he can be hired and fired anytime at the discretion of the president and the governor. Now, as a safeguard to this doctrine of pleasure, 311 is there, which is a very important provision. And as far as the CCA rules are concerned, the main fountainhead of that power is 311 only. 311 says that no person shall be reduced or removed or reduced in rank, removed or dismissed without following due procedure, and no person shall be punished without holding an inquiry wherein he's been given a sufficient opportunity to, wherein definite charges are framed and he's given a sufficient opportunity to defend himself. Now, again, it says that he cannot be dismissed or removed or reduced in rank by an authority which is subordinate to the appointing authority. Now, there are three exceptions to this also, which are provided under Article 311 also, that a person can be reduced in rank, removed, or dismissed without following the procedure of inquiry in case it is based upon a conviction, conduct which has led to conviction, meaning thereby that because of his conduct he has been convicted by a criminal court, and that conviction by itself is sufficient to dismiss him without holding an inquiry. Second, if holding of an inquiry is not practicable, reasonably practicable in the opinion of the disciplinary authority, and for that he has to record the reasons in writing. Third is the case wherein the president or the governor is of the opinion that it is not in the interest of the security of the state or the union that an inquiry should be conducted. In those cases, he can be dismissed, removed, or reduced in rank without holding any inquiry whatsoever. So this has been adopted in CCA also. We'll come to that also. So major penalties, as we specified, are clause 4 to 7 under Rule 14, and minor are clause 1 to 3. As far as major penalty is concerned, a elaborate procedure is provided under the rules. That is Rule 16, which deals with this aspect. And it is very interesting. It is just like a trial in a civil or a criminal case. And therefore, appreciation, although the judgments are that the appreciation of evidence cannot be gone into by the court. But again, like we discussed yesterday, case of no evidence, wrongly considering the evidence which was not a part of evidence, then not considering the evidence which is there on record, or error apparent on the face of record, or excess or lack of jurisdiction. These are the yardsticks under which, as stated, writ of certiorari, as we discussed yesterday, can be exercised. Same is the case in case of CCA rules also. Procedure wherein order is passed under after following CCA rules. So Rule 16 says, starts with this, that uh, I'll just churn out the rules in complete procedure and not go rule by rule, because reading that doesn't make any sense. That you can all read. I'll just specify that it says that no order imposing penalty under rule sub rule 4 to 6, 7 can be of rule 14 can be done without holding an inquiry. Now, for holding an inquiry, a definite charge sheet has to be issued. Charge sheet along with definite charges, meaning there were memorandum of charges, the charge sheet, and the statement of allegation on which the charge is based has to be specified. So there are some cases wherein it has been provided that even the list of witness and the documents which are to be relied upon have to be specified. However, our CCA, the Rajasthan CCA, doesn't provide any such rule. There might be some provision under the Central Civil Services rules of 19 CCA rules of 1965. However, in Rajasthan there is a only require in Rajasthan there is only requirement is that statement of allegation and charges should be definite. They should be communicated. Definite meaning they should not be vague. Specify the date of incident, the specific post which the person was holding, what was his dereliction of duty on his part. That all has to be specified. And the person concerned should be given a reasonable time to file a reply, denying or submitting in his defense or accepting the charges. So that is the basic idea. Now, there are cases wherein charge sheets have been challenged. The basic judgment is SR Bajwa versus High Court of Judicature for Rajasthan. That is the main judgment as far as Rajasthan is concerned. 84 RL, it is reported in 84 RLW, wherein it has been stated that if the charges are vague and not clear, and no person of ordinary prudence can understand the charges, then the charge sheet can be quashed. Otherwise, the courts are very sloth in interfering. Very rare you'll find that it is only in rarest of rare case that the charge sheet is quashed by the court. The idea is that they may hold an inquiry and thereafter, if there is no charge made out, he'll be exonerated. The delinquent will be exonerated. However, if charge sheet is an outcome of malafide or is vague and no definite charges have been framed, then the charge sheet can be quashed at that stage itself by the court, rather than asking the delinquent to undergo this ordeal of facing the departmental inquiry completely. Okay, so after framing of charges, the delinquent is given an opportunity that he can examine and inspect the documents which are to be relied upon, or which he thinks that will be relevant for defending him his case. So he can file an application that can be considered, and if there is a reason for rejecting it, then the reasons are to be recorded in writing by the authority concerned. Subsequently, post documents, there is an important aspect that the disciplinary authority may himself inquire into the allegations or appoint an inquiry officer who may conduct the inquiry. Usually in Rajasthan, this procedure is adopted that an inquiry officer is appointed by the disciplinary authority. Now, the inquiry officer is appointed before whom again the opportunity shall be granted to the delinquent, that if he pleads guilty of any charge, then it is well and fine. He'll issue the inquiry authority will record a finding of plead guilty and ask the delinquent to sign his signature upon the same, and the inquiry authority shall also sign it, and that shall conclude the inquiry. However, in case he doesn't plead guilty, then the inquiry shall be started, and for that purpose, on behalf of department, a presenting officer shall be appointed who shall present the case on behalf of department, just like we have a PP in criminal trial, public prosecutor. And the delinquent will be given an opportunity to appoint his defense nominee. Now, there is a rider as far as CCA is concerned, Rule 16 itself, that a delinquent can appoint a government servant. But a government servant cannot be a person who is having more than one, who is undertaking more than one disciplinary inquiry. Like he can act as a defense nominee for only one delinquent. He cannot act as defense nominee for in other cases also wherein inquiry is pending. And there is further rider that no legal practitioners can be appointed. However, an exception has been carved out that in case presenting officer is a legal practitioner, then definitely the delinquent also can employ a legal practitioner. Same is provision under the Industrial Disputes Act also, and in some other special laws also, wherein no legal practitioners is permitted. Thereafter, so post appointment of presenting officer and defense nominee, the list of witness is to be submitted by the presenting officer and the documents upon which reliance is to be placed. They are to be exchanged, and thereafter the first of all, the witnesses on behalf of the department are to be examined. The witness will be examined in examination in chief, just like in any other trial, and it has to be complete examination in chief, not on basis of affidavit. Affidavit can only be permitted only in case the witness is of a formal nature and not otherwise. Now, post examination in chief, the delinquent or his defense nominee shall be permitted an opportunity of cross examination. Then there shall be admission and denial of documents also, just like in any other trial, exhibiting of the documents. And thereafter, the there is a provision of recall of witness also, and production of new documents, just like in civil trial and criminal trial. There is one more provision that is probably I'm sorry, that is 16.6, which says that in case the delinquent does not appear, then the departmental authority, then the inquiry officer can proceed ex parte also. Now, what is more important is the record, the charge sheet, the reply, the witnesses, the documents exhibited. This all forms the part of the record of the inquiry officer. The inquiry officer shall thereafter churn out the evidence, consider each and every aspect of the matter, and give his finding, and submit this record along with the finding to the disciplinary authority. The disciplinary authority shall thereafter, reasons have to be recorded on each and every charge by the inquiry officer himself. The disciplinary authority shall thereafter either accept the findings, or he has got an option that if he disagrees with any finding, suppose inquiry officer has exonerated a delinquent from two charges out of three charges leveled, then the disciplinary authority can assign reasons for his disagreement. He has to, not can, rather, he has to assign reasons for his disagreement and send the same to the delinquent. The delinquent has to be given an opportunity to reply to that reasons for disagreement also. So that is one course. In case the disciplinary authority, after going through the record of the inquiry, is of the opinion that there is some basic lacuna in undertaking the inquiry, then he can ask for de novo inquiry, or may ask for rectification of the defect by conducting of a inquiry from that stage itself. Third option is that he may accept the report of the inquiry officer as it is, in case he is satisfied with that, and thereafter the final order has to be passed. Now, 16 sub rule 9 is very important, which says that the disciplinary authority shall record its finding on each and every charge That is a very important provision and which is much used in all cases wherein the challenge is to the order passed by the disciplinary or appellate authority. Recording reasons on each and every charge itself shows that there has to be application of mind. The basic idea is application of mind. And also, when application of mind for the reason that when a notice is given to the delinquent, he submits his reply and the representation as against the whatever he has to say qua the report of the inquiry officer. So those part has also to be considered by the disciplinary authority prior to passing the final order. Suppose there are 10 charges leveled against a person, and the disciplinary authority passes a combined order in one paragraph saying that yes, these are the charges and filed him guilty for all the charges. That won't suffice. The order has cannot be sustained on that basis. For each charge, charge A he has to give his finding, charge B he has to give his finding, charge 3 has to give his separate finding. So the idea is that application of mind and consideration of the entire record. Now, disagreement with the reasons we have given 16:9 is there, wherein this part has to be taken care of, that the charges are each and every charge is to be decided. The disciplinary authority shall thereafter impose the punishment, which it is under Rule 16, it is major penalty. And thereafter, the order of copy of the order has to be provided to the delinquent also. So, this is in short with regard to the major penalty. Now, minor penalty has been specified under Rule 7. I'll just skip that part as of now. Again, coming to the major penalty, the scope of interference. Since we are speaking with regard to, we are deliberating with regard to a law's perspective also, the procedure provided can be challenged, but not the findings. Findings can be challenged in rarest of rare case. So the procedure is very important. In case there is any lacuna, the procedure has not been followed under the rule as provided under Rule 16, then we can challenge the procedure and the court can interfere in that case. However, the finding of fact is concerned that yes, this was the allegation and I did not commit this allegation, that part, whether the evidence which has been taken has been shows that we have committed the delinquency or not, court will be very it will be interfered in very rare cases. However, if there is any procedural defect and we can show that a prejudice has been caused because of the non-following of the procedure, say for suppose the inquiry of report is not provided to us, then basic judgment was Union of India versus Mohammad Ramzan reported in 1992, wherein it was observed that in case that this inquiry report is not provided, then there is a major lapse and a serious prejudice is caused, and therefore the entire inquiry proceedings are vitiated. Now thereafter, EBIL versus Karunakaran's judgment came, wherein it was observed that the procedure has to be followed even if no request is made, inquiry report has to be provided. However, there can be certain cases in which no prejudice is shown to have been caused. In that case, it is not necessary to de novo start the inquiry. The inquiry can be restarted from that stage itself where the lacuna was caused. So that is all about the major CCA 16 Rule 16, which provides for procedure in case of major penalty. In case of minor penalty, the procedure is provided under Rule 17. Rule 17 is very simple, wherein the statement of allegation has to be informed and the reply has to be given by the delinquent. And if he asks for, now the important part is if he makes a request for personal hearing, then the opportunity of personal hearing will be given. If it doesn't ask for, then there is no requirement of giving opportunity of personal hearing, and straight away the order can be passed after considering the reply filed by him. But the reasons are to be recorded herein again. The reasons have to be specified. Yes, that after considering the record, these are the reasons. This were the statement. This is his reply. He is admitted or not admitted, and the reason that forms the part of the record. Now, there may be cases wherein initially inquiry is proceeded under Rule 16. However, the punishment can be imposed with regard to minor penalty considering the facts of the case. However, inverse cannot be done. In case the procedure is followed under Rule 17 and subsequently it is decided no, that the delinquency is a major one and therefore alleged delinquency and therefore the procedure punishment has to be major, then procedure under Rule 17 cannot be adopted. Then a charge sheet has to be issued under Rule 17, Rule 16, converted into Rule 16, and thereafter fresh procedure as provided under Rule 16 has to be followed. Then rule 19, I'm sorry, rule 18 is there, which provides for a joint inquiry. But suppose for a same incident, inquiry is to be conducted as against a person who is an employee, who is a member of state services, and also against a person who is a member of a subordinate services. Then the disciplinary authority or the appointing authority of the state service that is higher in rank shall be undertaking the shall become the disciplinary authority and undertake the procedure, undertake the inquiry, and joint inquiry shall be conducted in that case. Rule 19 again is verbatim repetition of rule article 311 subclause 2, wherein this is a case wherein without undertaking an inquiry the punishment can be imposed straight away. That is again in case of conduct which has led to conviction in a criminal case. Second is that the inquiry is not practicable to be held in the opinion of the appointing authority for reasons to be recorded. Now, reasons need not be communicated to the delinquent, but they have to be form a part of record. Because in case of a judicial review, the court will ask for the reasons, and that can be considered by the court and by no other authority. Now, conduct which has led to conviction is simple. Suppose I am convicted of offense under section 302, then my conduct and I have been then my conduct is sufficient to um, exercise this power and not to undertake any inquiry. So rule 19 can straight away be exercised. The third is that the governor is of the opinion, His Excellency the governor is of the opinion that security of the state is threatened and therefore no inquiry is to be conducted. So that are cases wherein uh, secure threat to the security is there. In those cases, straight away this power can be exercised. I'll come back to the second clause. Sorry, I forgot that part. The second clause where the holding of inquiry is not reasonably practicable. That is majorly in case when the person is very influential and he is in position to influence the witnesses. There to mere apprehension cannot be done, cannot justify. There has to be sufficient reasons for that apprehension also. Some logic, some justification behind that apprehension. And in that case, the reasons can be recorded by the authority and thereafter the order can be passed. Exercising powers under Rule 19. Thereafter, 19A is there, which is very again interesting, as I had stated earlier, that pertains to employees which are working on deputation under the state services, or who have been sent on come on deputation, member of union service who is on deputation here, or a member of corporation or an undertaking of the government who is working on deputation under the state services. In that case, the power of suspension can be exercised by the borrowing authority, that is the state government itself, and the information shall be immediately sent to the lending authority. Even in case of disciplinary proceeding, the power can be exercised, and prior to passing the order, the in case of major penalty, it has to be sent to the lending authority, or the consent can be taken by the lending authority. However, in case lending authority does not agree with the same, then the entire record is to be sent to the lending authority, who shall pass the final order in that case. Subsequently, moving forward to the last part of our discussion today, that is the appeal. So, classification and control we have already dealt with. Appeal starts from Rule 22. So, against an order of suspension, there is a remedy of filing of an appeal under Rule 22. Against an order of imposing of penalty, be it minor or major, there is a remedy of filing of an appeal to the appellate authority to the order to the authority which has passed the order under Rule 23. So under Rule 23, you may file an appeal against any order passed by any authority to a higher authority, to the appellate authority which has again been specified in the schedule itself. Limitation has been provided under Rule 25 to be 90 days. And now there is a typical provision. I'm sorry, the rule limitation 90 days, then thereafter 26. Rule 26 deals with the contents of the appeal, that the order details of the grounds of challenge and the memorandum has to be supplied. The submissions have to be made. Now, Rule 27 and 28 are very unique, wherein it says that the appeal shall be submitted to the authority which has passed the order itself. And Rule 28 gives the power to that authority to withhold the appeal if he assumes that it is not passed, the appeal is not filed within the period of limitation and there is no explanation for delay. Thereafter, in case the appeal is not in the form as specified, and that no appeal is maintainable against this order. And this is a very typical provision. I myself am lost to understand as to why this provision is there. However, there is some relief from this in as much as Rule 29 is there, which says that there shall be a transmission of appeal in case the appellate authority asks that yes, you provide, give me the details of the appeal which are pending with you, and all appeal details shall be sent. And in case the appellate authorities of the opinion, yes, it was a fit case of exercising power of appeal, then the appellate authority shall exercise that power. Rule 30 again will be important from a lawyer's perspective. It talks about the how the appeal is to be decided. Now, very importantly, it says that it has to be the appellate authority has to consider whether the procedure provided under the rule has been followed or not, whether the post following of the procedure the guilt could be made out against the appellant or not, and thereafter whether the penalty imposed is appropriate in consonance with the guilt or not. So, meaning thereby, appellate authority has also to assign reasons applied mind. That is again the major principle of natural justice, which plays role in this part also. And the order of appellate authorities are challenged on this ground in the writ petitions also. So very interesting is that procedure is followed or not. Second is that whether the guilt is made out. So procedural lacunas can all be challenged in the appeal. Guilt is made out is again that part wherein the evidence is sufficient or not. Evidence has wrongly been considered or important evidence has not been considered. There is so that part can be dealt with, and whether the concept of proportionality. Third part is the concept of proportionality. Suppose the delinquency is insubordination and appellate authority finds that yes, dismissal was justified, then it is fine. Suppose the delinquency was simply negligence, then the punishment of dismissal cannot be said to be justified, and therefore the appellate authority can has the power to confirm, vary, reduce, or even enhance the punishment. There might be cases in which the appellate authority is of the opinion that yes, the punishment imposed is very less as compared to the delinquency. Therefore, the appellate authority can enhance the punishment with the only rider that an opportunity of hearing is to be given to the delinquent, and thereafter the fresh order can be passed. However, in case where no inquiry under Rule 16 has been undertaken and a major penalty is to be imposed, then the appellate authority can itself undertake the inquiry or ask the appointing authority of the delinquent to undertake the inquiry under Rule 16 and thereafter submit the report to the appellate authority. Now, unique thereafter is a provision of revision. Revision is provided under Rule 32 of the Rules of 1958, wherein the appellate authority, in case no appeal is filed, can suo moto or otherwise exercise the power of revision. Same powers vary, confirm, or enhance the punishment again with the same rider that the opportunity of hearing is to be given. However, there is one more rider that this power cannot be exercised beyond the period of 6 months from the date of passing of the order of which against which appeal or revision has been filed. Now, thereafter, there is a power of review by the government in cases of order of punishment imposed on the employees of the state services, that is provided in the Rule 33. Again, same provisions because and the period is 3 months, and this power is available has been provided because there is no power of appeal as far as the punishment imposed is concerned qua the state services is concerned, employees of the state services. Now, thereafter, there is a last power, which is power of review. So, order of the disciplinary authority, appeal, and the last remedy available prior to approaching the court is the remedy to approach the governor by way of filing of a review. Review again, governor has to examine the record, consider whether the procedure has been followed or not, and thereafter enhance, vary, reduce, or confirm the punishment. Same powers. The limitation is 3 years as far as enhancement is concerned, not beyond the period of 3 years from the date of passing of the order that the review can be entertained by way of enhancing the punishment. However, reduction, there is no limit provided under the statute. So, this is with regard to the procedure provided. Now, very interesting question comes as to why this disciplinary proceeding, which cases disciplinary proceedings can be conducted. Now, that was conspicuously missing. So, to rectify that part, the Rajasthan Civil Services Conduct Rules came into force in the year 1971, wherein though misconduct has not been defined, but the X has been given, elaborate list has been given, which provides that this shall be a misconduct, unbecoming of a government servant, participating in strikes, um, then second marriage, now even sexual harassment at workplace, and many other 25 double A capital double A is there, and many other provisions have been added, which says that yes, this act shall be treated as a misconduct. And 3A, Rule 3A of Conduct Rules of 1971 specifies that in case of misconduct, a disciplinary proceedings under CCA shall be undertaken by against the delinquent. So these are the cases in short with regard to the disciplinary proceeding as to the manner in which the disciplinary proceedings are to be conducted. And this is applicable to the government servant. And the thread line is again the principles of natural justice. Now, the rules are not applicable as far as workmen are concerned who are governed by the Industrial Dispute Act, wherein again the provision is the rules of procedure has to be provided, and principle of natural justice again plays a very dominant role therein also. As far as private companies are concerned, there are big companies that are standing orders, and other provisions are there. So again, the thread line again is the principle of natural justice. So idea is that there should be no violation of principles of natural justice, and the employed delinquent should be given sufficient opportunity to make out his case, to prove his defense, and that is the basic idea of CCA. So probably I have covered almost all the parts of CCA: classification, control, and appeal. Now, if there is any query, let me know.
Uh, yes, sir. I do have a query. So it's regarding little off the topic, but it's more of a central government query, central government service query. So
Yeah.
basically, how DOPT is applicable and DOPT office memorandums are relevant throughout all the ministries in our nation, and secondly, how the DOPT OM supersedes everything regarding the central service rules in India.
Samarpit, as far as the first part is concerned, DOPT will be relevant, circulars will be relevant only in case there are no rules specifying governing the field. In case the rules are governing the field, then they will be applicable, and only in case there are no rules, then the guidelines can be issued, memorandums can be issued, circulars can be issued, which is a part of again sub-delegation, subordinate legislation. I'm sorry, and not otherwise.
All right.
We have more queries. We have one from Shambhavi. Shambhavi, can you hear us?
Yes, am
Yeah,
I?
go ahead.
Yes, good afternoon, sir. So my first question is, when a person can be dismissed without
Uh,
being convicted by trial court, what
Shambhavi,
happens?
I cannot hear you. There is some, your voice is cracking.
Shambhavi, there's a problem. Sandeep, you can also read the query in the chat box. Can you open the chat?
I'll just do that. I'll just do that. Okay. Yes, Shambhavi.
Say,
Yes, now you can
can,
please.
now can you hear me? Hear me?
Yes,
Yes.
yes, Shambhavi. Now you are loud and
Okay.
clear.
Okay. So, when a person can be dismissed without inquiry if convicted by trial court, what happens if after 10 years he's acquitted by the appellate court? Does he get reinstated? Or if not, what are his remedies?
He gets reinstated as if the order of termination was never passed. There is getting of judgment in this regard also.
Right. And he
It will
gets
be treated
salary?
as if his salary will be paid. It will be treated as if the order was never passed. So
Okay.
all benefits will be accrued to him.
Okay,
And
sir.
there's another question by Shambhavi. I think
Yes.
Shambhavi, go ahead, continue.
Yes.
Yes.
So, what amounts to application of mind when we were talking about the orders of dismissal, termination? So, oftentimes we see that the disciplinary authority merely quotes the inquiry officer's report and thereafter he says, I agree with this view. So does that amount to application of mind? And can the order passed in such an manner be called reasoned order?
Shambhavi, it cannot be said. If you know, if you are aware, we have dealt with many cases in this regard. And the basic judgment, as far as this, although Tulsi Ram Patel 85 Supreme Court is the basic judgment, but SN Mukherjee versus Union of India 1991 Supreme Court is there, which says that the disciplinary authority has to assign it reasons. Assigning reasons on each and every charge 16.9, that is the reason why I said 16.9 is very important. For assigning reasons on each and every charge, you cannot say that the order of the finding of disciplinary authority are correct and I adopt them. There is a mandate that you have to consider the entire record as application of mind is there, in meaning thereby that the entire record has to be trashed once again. My representation has to be considered post the report of the disciplinary authority, and thereafter you will give your independent finding on each and every charge. So that is the mandate of 16.9 itself.
But on a practical level, like we see the orders that does not oftentimes happen, and it becomes a ground for challenge, of course. But many times we also fail in this challenge.
See,
So
in whenever these sort of orders are passed, they are challenged, and council are you like you appear, you have got many of them set aside.
no, sir, not.
Many, there are 18 of cases, and
No.
that is the basic requirement of principles of natural justice, which cannot be undone with.
Right. Thank you, sir.
Even
Thank you.
even if I'll go just one
Yes.
step ahead.
Yes.
Even if the appellate authority says that I agree with the finding of disciplinary authority, that itself has been observed by a number of judgments by this honorable court and the Supreme Court also, that won't suffice the purpose. The entire proceedings, the order has to go, and the appellate authority has to apply its independent mind also.
So that answers my query. Thank you.
There's another question. Oh, Sanjeet is back. There's another question by Sanjeet. Sanjeet, can you hear us? Oh, Sanjeet, instead of unmuting himself, has muted Sandeep. What's happened? Sandeep, you'll have to unmute yourself.
I've done that, Kasi.
He's still not online, so I just ask. He says difference between dismissal, removal, and termination.
Can you hear me, bhai?
Yes, now we can hear you.
Dismissal
bhai.
and removal.
Yeah.
Yep.
Dismissal, removal, termination. I think everybody should know that what are the difference, because it appears to be similar words, but it has its different repercussions and implications. Yeah.
You are late to join, bhai. I have already discussed them.
Sorry then. Sorry. Then just to add one input. What Shambhavi has asked, that what happens if the criminal courts acquit somebody?
Yes.
So in that case, there are many judgments, Sandeep bhai, जिसमें कि उन्होंने ये कहा कि there is a difference between the proof in the criminal cases as well as in the proof in the departmental inquiry. So in all the cases where the fellow has been acquitted, doesn't always ipso facto result in restoring him in service, because
Sanjeev,
there the proof
continue, please.
Yeah, so because there was the proof was required beyond all reasonable doubt, and here the standard of proof is preponderance of evidence.
Probability.
Yeah, preponderance of probability. Sanjeev, that to answer that query, in case inquiry is held, complete inquiry is held under the CCA, and thereafter the delinquent has been punished. In that case, it will not be that he'll be reinstated immediately on acquittal, because the preponderance of probability and beyond reasonable doubt is the rule of the day, and therefore he will not be reinstated. But in case no inquiry is conducted and powers under Rule 19 have been excised, then immediately on setting aside of the order, he'll be reinstated with all benefits.
So that was the only clarification I wish to bring in. That's it.
Yes,
I understand.
thanks for that part.
In continuation of the same, does it make any, is that the principle that has to be invoked of which we now loosely call it as honorable acquittal? So if it is honorable acquittal,
you're right. Yeah.
All gone in. Otherwise, if it is on the same theory of proof beyond doubt and preponderance of probability.
because there is nothing like honorable acquittal or uh, identical case in or anything identical in service law. It simply talks about acquittal. Honorable acquittal you won't find rather anywhere. It is simply an acquittal for whatever reason. If he is acquitted,
I
then
I think
he'll be.
I think Vikas Bhai is trying to say that if the fellow has been acquitted while giving benefit of doubt,
Yes.
so
Then
whether
too,
in
then
that
too.
so, so then also whether he will be entitled for reinstatement, that is, I
Yes,
think, is
yes, yes. Because the reason is that there is no concept of honorable acquittal or acquittal on the basis of benefit of doubt. The concept is
yeah.
simply that in case he is acquitted, then he shall be reinstated with all the benefits, irrespective of the
Yeah.
manner in which he has been acquitted.
So that's true that nowhere, in fact, criminal law does not talk of honorable acquittal. Acquittal is
Right,
acquittal. But
right.
Yeah.
yet in various places where there's a consequence of a criminal conviction or otherwise of it, the
Mhm.
courts for other jurisdictions have started looking at in from the lens of an honorable acquittal to make the distinction between whether he's been acquitted for lack of evidence or acquitted by finding him not guilty. So
But
it's
that is,
that.
see, that
Can
part
I
is
add?
also recently considered as far as appointment is concerned. In case of Avtar Singh's
Mhm.
2016 versus state of Punjab. So therein again, relying upon various circulars and the other aspect, it was observed that acquittal is acquittal. However, as far as appointment part is concerned, the state can still consider the nature of the acquittal and the nature of the delinquency,
Right.
but not
Uh,
for disciplinary proceedings. It is only in
I
case of appointment.
A
cool.
small thing to add, Sandeep bhai, if the earlier punishment was based upon the conviction order, and that has been later on set aside on the ground of benefit of doubt, whether
Right.
the employer can reinitiate the inquiry, saying that where there he got the benefit of doubt, but since he is not honorably acquitted in that sense, so therefore we can proceed with the full-fledged inquiry on ourselves.
Yes, there is no embargo, Sanjeev, as far as these rules are concerned. Employer is within his discretion to proceed. However, the time frame will be important because there have been judgments wherein after a long time, if a charge sheet is issued after lapse of a long time,
Yeah,
then
yeah.
it cannot be entertained, and then that procedure cannot be permitted because the evidence he'll not be the employee concerned will not be in a position to prove his defense also after such a long time.
Yeah, right.
We have another question from Vandana. Can you hear us, Vandana? Uh, Vandana, you'll have to
Um,
unmute yourself.
yes, I have done that. Can you
Yes,
hear me now?
carry on. Ask your
Yes,
question.
yes.
Yes. So my two questions were definitely answered by him, but now the question is, it is with regard to the deputation wala thing. So the question is, if the cases of sexual harassment in the borrower department, so like the incidents happened in that department, but the lender department refuses to initiate any proceeding against that person. So in that case, what will be done?
So the borrowing department will be deciding whether proceedings are to be initiated or not. The borrowing department can suspend the person concerned. If the borrowing department in the present case, like is a state government,
Right.
they can suspend the person, initiate the departmental proceedings, and do the needful. And only prior to passing of the order, it has to be sent to the lending department in case there is a difference of opinion, and
So
not
you mean to
otherwise.
say that inquiry will be conducted, but the
Yes.
final order will be passed by the lender department.
Yes, by
Okay.
the final lending department. And there is one provision. Since you have raised this question, I'll just specify 18 capital A was introduced
18A,
recently.
right? 18A.
So even in cases of that nature, the complaint committee, which is established in the department for inquiring
Yes.
into sexual offences, it
Right.
has been observed that this report by the committee itself can be treated as a disciplinary proceeding, and they may proceed in consonance with the rule 16 of the 16 or 17 of the rules of 1958.
Okay. Okay. Thank you.
Thank you.
Uh, yes, we don't. I don't think we have any more questions. We're also coming to the end of our time. One query, just as a hypothetical situation, would the change in terms of the service to the detriment of the original terms of service without any change in rules, would it
Because can you just repeat once again?
I'm saying that if there is any change in the terms of service to the detriment of the person or a class of persons without any change in the rules which govern
Mhm.
them, would it in effect amount to a disciplinary action? I'll tell you why this question comes up, and it'll lead to our food for thought for the day, where I'm leading to is uh, uh, anything which is to your detriment done without giving an opportunity to you is the principle. So the question would be, if it is considered in terms of a detriment to your service, then would there be any recourse under CCA rules? Because there has been no, just randomly terms and conditions have been changed.
No, Vikas, it cannot be until unless there is a punishment as specified under Rule 14. It is only in that case that CCA come into force and not otherwise. In case there is any detriment change in the service rules for the detriment of the employee concerned, it probably can be only by way of amending the service rules itself and not otherwise. In case there is any order issued by the department, then that can be challenged and that will have to go anyhow.
Correct. So the food for thought was, because we are in this, we're trying to link everything to what is happening now.
COVID.
So COVID times, what the central government and most state governments have done is reduced the salaries. Though under the notification under the Epidemic Act to the private sector, they've said the salary is not to be reduced, but this governments, respectively center and state, has gone ahead and done it.
So
What
that is
is the recourse? Because there is
as
no
far
amendment in the rules, there is no assumption of authority. So purely academic, I'm not going on the morality of the issue, whether it should be done or not. Purely legal academic question for everyone to whether this could have been done, or if it could have been done but after following a certain specific process or amendment, or it could have been done in the way it has done. And lastly, if I do not, as an employee, I do not agree with the government, I don't want my salary to be deducted, what recourse do I have? I mean, that's
yes,
the broad for everyone to think about. This is a purely, I mean, this is not a question on morality or the correctness of the decision of the government. It's essentially only on the legal question that it proposes. So I think
correct.
we'll be all be happy to have everybody's inputs on what they think on this situation. Thank you, Sandeep. It was
Thank
a
you.
wonderful, it was really a nice walk, let me put it that way. Despite the bad weather outside, it was a really nice walk through this. Glad to have you here. I think everybody has enjoyed it. Everyone, thank you for joining in. It's always nice to have more and more people. We had a few new people joining in. For those who have come in for the first time, just for their benefit, please feel free to invite everyone. This is not these are not sessions by invitation only. This is open for everyone. It's just that we haven't been able to reach everyone. Also, we didn't want to sort of oblige people to come in and join in by sending in specific requests. So please spread the word. Anybody who wants to join in on our daily discussions can log in at 11:30. Samarpit and Sachin can add you on, and even if and the link can be shared to everyone. These are public links. Everybody can join in. We have ample capacity, so that's not a problem. Hopefully, see you everyone tomorrow, and invite anyone you want to. Tomorrow we have Sanjeet speaking to us on some environmental issues. We'll circulate the link. And on Monday we have Sunil talking to us on the documents and some of the terminology, peculiar terminology used under the revenue laws. So thank you. See you tomorrow. Bye.
Thank
Thank
you.
you
Thank you
again.
all.
Thank you so much for coordinating.
Thank you, sir. Thank you, sir.
Thank you, sir.